reasonable excuse. My name is Tammy Yowie.
You're going the wrong way.
I always want to be a transgender.
Come on, honey.
Setter. Can't even speak good English.
Tell me when.
Welcome. This afternoon, we have Freedom Team A on the affirmative and Easton Team A on the negative. The resolve is as follows. There are viable reasons for the insanity plea. One. Ready? Is the timer?
Yep.
Okay, ready for our first affirmative constructive speaker.
Good afternoon. Good afternoon, distinguished judges, fellow debaters, teachers, and students. We are here today to discuss the insanity plea. The insanity plea is a defense against responsibility for a crime. This is to say that if a person is not in their right mind at the time he or she commits the crime, then that person is not legally responsible for their actions. The U.S. Supreme Court has ruled that an incompetent defendant may not be tried in a court of law. In legal terms, insanity is defined as a mental defect or disorder sufficient to prevent a person from knowing the difference between right and wrong conduct, or from no understanding the nature of his or her actions. If the will of the criminal is so completely destroyed that he or she has no control over said actions, this person can't possibly know he or she is doing something wrong. This means that if a person is insane at the time he or she commits a crime and was not aware of this inequity, then this person is not responsible for his or her actions. To legally prove someone is mentally ill, you must look at three major issues. 1. Competence to stand trial. 2. A degree of responsibility for the commission of a criminal offense. And 3. Imposition of an appropriate sentence after conviction. In order for the defendant to be competent to stand trial, they have to be mentally sound on the day of the trial. He or she must understand the alleged crimes which are being charged against them. The mentally ill can't possibly understand their own wrongdoing, much less the punishment they are to receive. To be found mentally ill says that you are not responsible for your actions, and that you need special attention from a trained professional. If someone requires special attention, they can't just be put on trial in front of a jury like any other person. If by chance this person was found guilty, he or she would be sent to prison, and in the case of first-degree murder, sentenced to death. This is hardly the right place or circumstances for someone who is mentally unbalanced. If you were to take away the insanity plea, it would be giving these helpless people nowhere to turn. Instead, let them have the option of pleading insane, as this man did. 14 years ago, John Smith tried to drive a Greyhound bus out of the New York City Port Authority bus terminal in cash. His lawyer pled that Smith was not guilty by reason of insanity to the charges of grand larceny. Smith was acquitted, but has been confined involuntarily for 14 years to a mental hospital, which is longer than he would have spent in prison. When people say pleading insanity is just an easy way of getting out of going to prison, they're sorely mistaken. When it comes to the insanity defense, the media focuses only on people who are quickly released and those who have committed violent crimes. This causes many Americans to think that most criminals use the insanity plea so they can get off easy. Someone who is mentally ill and needs special care will completely collapse in prison. They need to be in an environment where they can be looked after and treated for their problems. According to researcher Henry J. Steedman, the number of people who use the insanity plea is very small. There are, said Steedman, only about a few thousand each year in the entire country. A report published by Policy Research Associates shows that 85% of the people who are found not guilty by reason of insanity are sent directly to mental hospitals, and some confined for longer periods of time than they would have spent in prison. Critics of the McNaughton Law, which was formed in England in 1843, argue that it should be abolished because they see it as a loophole for people who break the law to dodge just punishment. But a study conducted in 8 states found that the vast majority of people who use the insanity defense were seriously mentally ill. The insanity defense shouldn't be thought of as an easy way out for criminals, but as a means of assistance for someone who needs it to get the special attention he or she would not be getting in prison. Thank you.
403.
Yes. When was the monotony rule changed?
When was it changed in, I believe, 1915?
Thank you.
Oh, this is something, I believe.
What relevance does British law have on the United States judicial system?
For a while, the McNaughton rule was the basis of a test used for people who were tried for being mentally ill.
And this is this supposed to say that the Americans should follow the British standard of legal systems?
Well, it's not. Americans and people all over the country follow things from other countries. I mean, our language itself is based on many different languages around the world.
How exactly is insanity determined in a trial?
There are a trained professional psychologist test the defendant. Many different tests.
Could you give me some examples of a test? Thank you. Are you saying that there is no responsibility when a mentally ill person commits a crime?
Yes.
Why is that?
They're like a little child. I mean, if they don't know what they've done is wrong, you can't very well hold them responsible for it.
What about cold-blooded killers who do not feel guilty, but they do not believe what they are doing is wrong?
That's like, if they do not believe what they're doing is wrong, then they're not really aware that it is wrong, the difference between right and wrong.
You mentioned children. Are they also not punished merely because they do not know what is right and wrong?
I mean, they're punished, but not as severely as they would have been if they
Should someone teach them the difference between right and wrong?
Yes, their parents teach them the difference.
I'm talking,
There
should someone teach convicts right from
Convicts.
wrong?
Yes, that's why they're going to the mental hospital to be treated, and during their treatment, they're taught the difference that what they have done is wrong.
Are you aware about the abortion clinic killer,
No, I'm not.
John C. Selvey?
I'm not aware of it.
Are you aware of the difference between the legal and medical definitions of insanity?
Vaguely, yes.
Would you please define the legal definition?
Legal definition is when a person is not competent to stand trial.
How is that determined?
By, like I said, many different tests, which before you make it aware that I was not able to name them, yet they are made of different tests by psychologists in the court. Stop.
Mrs. Trimble, we had people stand under the microphone last time in the broadcast. Can we do that?
Yeah,
Yes,
do that.
microphone's right here.
Good afternoon. Today we are here to discuss and debate both the affirmative and negative sides of the insanity defense. We, the negative team, feel that the plea of insanity is ineffective, morally wrong, and blatantly abused. The affirmative team will present you with facts and specific cases where the insanity plea has been used successfully in the acquittal of certain defendants. This is where the main problem of the insanity plea lies. How can we justify the act of acquitting a man when he has admitted to committing a crime? The simple fact is we can't. Whether he was sane or insane, the criminal must still pay for his crimes. For instance, take Mark Austin, a citizen of Arizona, who brutally murdered his wife. In a fit of supposed insanity, he stabbed his wife 7 times in the chest. For leaving him, Laura Griffin Austin had left her husband after he began to verbally abuse her, after which Mark began to stalk and harass Laura. One night, 2 months later, he snapped. He killed Laura and critically wounded her longtime friend Tom. Mark was found to have been temporarily insane. At the time, he was sentenced to 120 days in a mental hospital, after which he was found to be cured of his brief reactive psychosis, although he was still a threat to society and believed by psychiatrists to have a severe personality disorder. If Mark was insane, which he testified as, and was later found to be, although to a more significant degree, why was he allowed to walk free? The man committed cold-blooded murder. Why was he not punished? Furthermore, doctors and psychiatrists believed he was still a danger to society and he was not cured of his illness. Then why is it he can walk the streets of Arizona today? The answer is another major flaw of today's insanity plea. Arizona law states that since Mark's other disorders were established after the trial, he need not be cured of the other illnesses when he is released. Plus, doctors state that Mark felt no remorse for his act. How can we stand by an insanity plea that lets a still dangerous man walk the streets? Ladies and gentlemen, the answer is again, we cannot. The negative team also believes that the insanity plea can be easily manipulated and thus abused. The insanity plea has many flaws. One of the major flaws is the complete lack of standardized testing. In fact, just about every state has a different test. The first test, which is still used in some areas, is the Durham test. This test only identifies the mental condition, but not how it relates to the crime. For example, if someone shoplifts a purse and is found to be schizophrenic by using the Durham test, that information is allowed to be presented in court, even if it has no bearing whatsoever on the court case. The Monotone test has two major criticisms. First, it does not take a sufficient account of psychiatric realities or scientific knowledge into consideration. Second, it is still only based on one test. The American Law Institute test, which consists of two parts, depends on the defendant's understanding of the implications of the crimes, which is based on a conversation held with the defendant's lawyer, and second, on the irresistible impulse test, in which case the defendant is given the chance to break a crime with the obvious presence of a police officer. If the defendant then breaks the law, it is said that the defendant is insane. As you can obviously see, all of these tests can easily be faked. If a person has committed a crime and has the choice between years in prison and 120 days in an institution, the obvious choice would be the 120 days in an institution, after which they could go back into society. In fact, each state of the three tests, from the American Law Institute to the Monotone to the Durham, all of which have been amended differently. This shows with painful reality how what is insane in one state is not in another, so there is no precedence. Even the American Psychiatric Association noted that many trained and licensed psychiatrists believe that the information presented is irrelevant in most cases involving the insanity plea. If even psychiatrists, the people who are giving the test to the possibly insane, believe the information is irrelevant, then how can you expect the jury to take it seriously? The answer is plainly, once again, you can't. In fact, using the insanity plea as it stands today, the jury doesn't have to take any of the information about the defendant's insanity seriously. The jury is not required to depend on the selective symptoms. This lets the jury just consider right and wrong like they would in any other case, and effectively lets the jury circumnavigate the whole plea of insanity. With all the abuses of the plea and the very large hole I have just mentioned, it is very easy to see how when Dr. John Phillips and Dr. Mark Wheeler were taking a survey of people in an asylum, most wanted to get out, not get well. We stand firmly by the fact that the insanity plea today is morally wrong and has too many holes in it for criminals to move around. No reason can be viable enough to allow such an act to continue its existence in our judicial system. Thank you.
Are you aware that recent studies have been done proving that out of all the cases, over 50% of the people who plead insanity are really insane?
50% of what number?
Out of 100.
Out of 100. That's 50 people out of 100. That's a lot.
But over 85% of those are sent to hospitals for longer periods of time than if they had been sent to a prison.
They still have not served their debt to society, and they have committed those crimes.
But if they don't understand that they committed those crimes or that what they did do was wrong, how can you send them to jail for something they don't know?
Ignorance of the law is no excuse.
So someone's insane and they don't understand what they're doing and you're punishing them for that.
They should be made to understand what they did and why it's wrong, and then serve out their debt to society.
But they understand what's wrong by going to the mental hospital, and they stay there in most cases longer than going to jail, so they do serve time.
But a mental institution is much more plush than a jail.
But they should go to jail with hardened criminals.
Yes, because that's where society puts the criminals. And a criminal is someone who has broken the law.
But they're not really a criminal because they don't understand what they did was breaking the law or that it was wrong.
They still broke the law.
But they don't understand it.
And they should be made to understand it and then serve out their time so that they can start over with a clean slate in society's consideration.
But what if they're insane their whole life? and then they committed a crime later on, why should they go to prison? Because they have never understood the difference.
And someone should have pointed out the distance, or because of civic duty, they should have gone and gotten help.
Well, maybe they were like a child when something happened and they have like a chemical imbalance. And how could you be pointed out to the difference between right or wrong?
There are treatments that you can have for chemical imbalance, and people teach children the difference between right and wrong.
And the child doesn't understand, and they grow up, and they commit a crime, and you throw them in jail for something that they never understand. When they can go to a mental hospital and be given the exact care that they need, the treatment and the drugs and everything else, and they serve longer time.
If they had a chemical imbalance or whatnot to start out, they should have gotten treatment for that, and then they would have never committed the crime.
Honorable judges, fellow debaters, teachers, and students. Are there viable arguments for the plea of insanity? And if so, what are they? Insanity is legally defined as a person's state of mind at the time the act was carried out. There are many justifiable cases to speak of. For example, when Lyman Bostock was shot and killed by Leonard Smith, he was sitting in a friend's car with his friend, Leonard Smith's wife, and her sister. Smith thought his wife was having an affair with Bostock, so he shot him in the head with a 12-gauge shotgun. Leonard Smith was found not guilty by reason of insanity. He received treatment and was released after 7 months. There are many controversies over the insanity plea. Most people think that the insanity plea is a way of getting out of doing time, but it really gives the accused a way in. Instead of going to jail, the accused person can get the help that he or she needs in a mental hospital. Out of all the insanity acquittees, about 90% spend time in custody after being found not guilty. Of the ones acquitted of murder, the percent rises to almost 100. And out of all the insanity pleas, only 14% and 15% of the acquittals involve murder. Most people think the insanity plea is wrong, but the only cases that they have heard are the ones with quick releases or involving violent people. Only a few thousand use the insanity defense in the entire country. And out of all the people who used the insanity plea, 62% were diagnosed with some mental illness, and 72% had been hospitalized once or more. Those who were found not guilty by reason of insanity in a murder case had a median confinement time of 6.5 years. In the 8-case study, the insanity acquittees were locked up for a median of 637 days. Convicts who were sent to jail have a median of 679 days. It is in a wide range in differences, especially if these insanity acquittees are getting the help they need. The first case of the insanity plea was in 1843 when a man named McNaughton shot and killed a member of Parliament. He was tried and acquitted because the jury found him not guilty by reason of insanity. After a protest, the Queen's Bench formed a standard to determine mental responsibility, which became known as the McNaughton Rule. In the United States, there have been many jurisdictions that have replaced tests for one called the Model Penal Code in 1962 by American Law Institute. It states that, quote, a person is not responsible for criminal conduct if at the time of such conduct as a result of a mental disease or defect that he or she lacks substantial capacity either to appreciate the criminality or wrongfulness of his or her conduct or to conform his or her to the requirements of law, unquote. To determine a person's mental condition, you need to look at 3 major issues. 1, competence to stand trial. 2, degree of responsibility for the commission of a criminal offense. And 3, the imposition of an appropriate sentence after conviction. For a person to be competent to stand trial, his or her mental condition is looked upon at the time of the trial. The United States Supreme Court has ruled that a person must understand the grounds against him or her. In 1984, President Ronald Reagan signed a legislation after almost being assassinated by John W. Hinckley Jr. on March 30, 1981, which restricted the insanity defense in federal cases. A person found not guilty by reason of insanity in a federal system is placed immediately into a mental hospital until a judge is convinced that he or she is no longer a danger to himself, herself, or to others. As I said earlier, don't think of the insanity plea as a way out, but as a way in for the accused to get the help they so desperately need. Thank you.
Okay, you had mentioned Mr. Smith at the very beginning, who had killed a man that he thought was having an affair with his wife. Did you say that he was treated and released?
Yes.
How did he pay his debt to society?
He doesn't understand what he's doing. So when he is put in a mental hospital, he's sort of learning.
So are you saying that merely because he was angry at the time, that is an excuse for killing the man?
No, it's not an excuse. And he was not. No.
So if a person believes something is happening and becomes very angry, then they are allowed to do this, to kill and get mental treatment and then be released?
No, they're put in the mental hospital to get help. But he was.
Thank you. You had mentioned the American Law Institute test. Now, are you aware that that test was found to be unreliable and was later abandoned?
No.
Can you also say how a judge determines when a person is to be released from a mental institution?
Yeah.
How is a judge an authority on insanity?
It's in a federal case, and he decides when the person has enough treatment by what.
How is the judge an authority?
Well, the psychologists, they research and see how the person is doing, and the judge has to decide once he is sane enough to be released.
Is it possible to fake the tests to determine insanity?
Yes, but in most cases it doesn't happen.
How do you know that?
Well, because there's studies that have shown that the people who.
You mentioned 62% of people are actually mentally ill.
Yes.
Where did you get that statistic?
There is. We have. We found papers on the information. I can find it for you.
What source did you use?
That one was, I believe, on a computer. It was from.
A computer.
It was like on like Encarta, you know.
Okay. Thank you.
Good afternoon. My first speaker has established that the insanity plea is morally wrong and that it is abused by criminals in our society. The affirmative team has tried to relate the idea that a man who has committed a crime can be acquitted due to his mental condition. Unfortunately, ladies and gentlemen, this is just wrong. This is just morally wrong. We, the negative team, stand firmly in the face of justice. We believe that when a crime is committed, a man must pay for that crime. After all, is that not the purpose of our judicial system? The current insanity plea, as my first speaker has stated, absolves a person of all responsibility due to their mental illness. But as he has also shown, the plea does not always work the way it was intended. We believe it is a time for a new alternative to take its place. We propose a system that's already been accepted in place of the insanity plea in more than 10 states, including our own state of Pennsylvania. We are proposing the guilty but mentally ill defense. The guilty but mentally ill defense is a much better alternative for both criminals and members of our society. It is extremely difficult for a jury to make the decision of whether or not to A, find a person who did a crime guilty and send him to prison without psychiatric treatment, or B, finding him not guilty and say that he had no responsibility for that crime. Also, as my first speaker has pointed out, that person could walk in as little as 120 days. The guilty but mentally ill defense solves all of these problems. In this plea, an admitted criminal is found guilty for his actions. He will receive a sentence which must be completed. However, instead of sending him to jail without treatment for his illness, he will receive treatment while serving out his sentence. In June of 1991, psychologist Margaret A. McGreevy of Policy Research Associates in Del Mar, New York, gathered information on 1,300 cases between the year 1979 and 1982, where defendants plead not guilty by reason of insanity. 662 of these cases received insanity acquittals. Many judges are ruling out the insanity defense altogether. For example, in the case of John Salvi III, a man who was accused of killing an abortion doctor, he was not allowed to plead not guilty by insanity. And one of the most prominent cases that had a great impact on the insanity defense was the Hinckley case. And jurors in that case have stated that they would have rather used the guilty but mentally ill option if it was presented to them. Many states narrowed their legal definitions of insanity in hopes of undermining the attractiveness and success of the defense. Yet it hasn't had a significant impact on the use of the defense because, as shown in the facts above, there still have been 662 acquittals. As you can see, this part of the judicial system must change, and by using the guilty but mentally ill defense, it can. The guilty but mentally ill defense has already been successful in such states as Illinois, Alaska, Delaware, Georgia, Indiana, Kentucky, New Mexico, South Dakota, Utah, and Pennsylvania. By making sure criminals are serving time and getting treatment they need, they will not be a threat to society, but will be able to aid in the growth and change of it. A good example of how the guilty but mentally ill alternative would be more effective is in the tragic case of star Nebraska running back Scott Baldwin. On January 18, 1992, Baldwin, who was labeled by Nebraska coach Tom Osborne as the quickest man in Cornhusker history, attacked Gina Simonik on a quiet street in Lincoln, Nebraska, putting her in a coma from which she miraculously recovered a few days later. However, in the ensuing trial, Baldwin was found not guilty by reason of insanity. And not long after his release, he went on another psychotic rampage during which he brutally attacked a police officer. The police officer was forced to shoot him, leaving him permanently paralyzed from the waist down. He was later diagnosed as a paranoid schizophrenic, a mental illness that doctors had originally classified cured. If the guilty but mentally ill verdict had been used in this case, the two injustices would have been righted. The first is that Scott Baldwin would have been found guilty of attacking Gina Simonik, instead of being acquitted of all responsibility. And the second is that Scott Baldwin would be able to walk today. Since the guilty but mentally ill verdict requires a longer sentence, doctors have an opportunity to further evaluate the condition of a criminal. Obviously, when Scott Baldwin was released from his mental institute, he was not cured of his mental illness. Responsibility is the key to a working society. The negative team has proven that if a crime is committed, no matter what the circumstances, the criminal must be held responsible. And with our plan, the guilty but mentally ill defense, that is made possible. The criminal must understand the consequences of his actions. Our justice system is designed to protect the innocent, and the only way to do that is to make the guilty pay their debt to society. We have shown that not guilty by insanity does not make people pay. Thank you.
Would you please define mentally ill?
Mentally ill, a person, it's an imbalance in your brain. It's if you're slow. There's so many. It's such a complex term.
Well, would you define insanity?
No, that's a legal term, and that is just if you're insane, if you have a problem, a disability, or if it's a very broad term.
It's a disability when you don't understand something. So wouldn't insane and mentally ill be the same thing?
No, they are different. Because, well, insanity is just the insanity is a legal term, and mental illness is a medical term. That's the difference.
Okay, and you said that mentally ill is a disability, but if you're disabled, does that mean that you're insane?
No, it's mental incapacity, and we're not blaming anybody for being mentally ill. We are saying that if they commit a crime, if you commit a crime, no matter what, no matter if you're sane or if you're mentally stable or if you're mentally ill, you still have committed that crime, and you must pay your debt back to society for that crime.
Oh, you were saying that you don't blame them, but in a way you are because you're throwing them in jail for something they didn't understand.
I'm not throwing them in jail. Our plan that we've devised says that they will go to a psychiatric hospital to get their treatment, to understand and to learn and then once they understand their crime, they have to complete their sentence in prison, yes, because that's where we put people who commit crimes.
Okay. For the guilty but insane plea. Do you know that Michigan abolished the insanity defense in favor of that plea? And, however, the number of insanity pleas in the state did not decrease even with the plea.
Well, it doesn't matter if the number of them decreased, if they were all valid. How many of those were valid? I mean, do you have statistics?
Research was done by Henry J. Stedman that said 85% of them.
Stop.
Okay, time when they have 5 minutes to prepare rebuttals.
Okay. You give one to one person, you give one to everybody.
Okay, 5 seconds. All right. All right, are we ready? Yeah. Begin with our affirmative rebuttals.
Negative.
Negative, sorry.
Good afternoon. Today the negative team has shown you the wrongs of the insanity plea of our era. My first speaker has proven to you that the insanity plea is not only morally wrong, but that it can be easily manipulated by the criminals of our society. We believe that when a crime is committed, a punishment must be given for that crime, no matter if you're insane or sane. My first speaker has brought to your attention the case of Laura Griffin, who was murdered by her husband, Mark Austin. As he has stated, Mark was absolved of all responsibility for that crime. Ladies and gentlemen, this is unacceptable. How can we say that a man who brutally stabbed his wife has no responsibility because he was in a fit of anger? Our Declaration of Independence provides that each person has a right to life, liberty, and the pursuit of happiness. Mark Austin took all three of these rights away from Laura Griffin. Shouldn't our judicial system at least take Mark Austin's right to liberty? Furthermore, doctors still felt that Mark was a danger to society, but that since he was cured of the disease he was found not guilty by, the Mental Health Board let him go. Obviously, there is something wrong with what occurs after a not guilty by reason of insanity verdict is reached. However, my first speaker has also shown you what can happen during the trial. The decision of whether a man is sane or insane is a very complicated one. States have tried to make the picture clear by using tests to make that distinction. Unfortunately, these tests can be circumnavigated with ease. We have mentioned the Durhan test, where the only item needed to prove insanity is a mental illness. That means if I'm dyslexic and I commit murder, I can get away with that. How can we stand by a plea that allows this? My second speaker has brought to your attention a much better alternative to what our system uses, the guilty but mentally ill defense. Currently, most states provide a jury with two options, either giving a dangerous person the opportunity to be released into society after some treatment, or sticking that person in jail where he will receive no treatment whatsoever. As she stated, the guilty but mentally ill verdict will make up for this problem. When a defendant is found guilty but mentally ill, he will receive treatment for his illness and then serve out his full sentence like any other prisoner. We are not blaming people for being mentally ill. We are finding them guilty for crimes committed. I mean, if the person who committed the crime is not responsible, then where does responsibility lie? The affirmative team has stood by the idea that it is immoral to place an insane person into prison without treatment. This is why the guilty but mentally ill defense is much better. It is unethical to say that a man who committed a crime had no responsibility due to his mental state. The simple facts are that he committed that crime. As I have already said, the guilty but mentally ill defense will not only find a man guilty, but also give him a treatment for his illness while he pays his debt to society. The affirmative team also said that the only thing required to determine insanity is a lack of competence for that crime and a lack of responsibility. They mentioned the case of a Mr. Smith who killed his wife's supposed lover due to his jealousy. He was then found not guilty and absolved of all responsibility. I mean, come on, does this seem fair? If I'm upset with my teachers for giving me a bad grade, does that make me insane and give me a right to kill him? This case is just another example of how the insanity plea is failing. We have been constantly told by the affirmative team that an insane person is like a child who doesn't know the difference between right and wrong. This is where civic duty comes in. If a person is insane, it is his duty, and those around him, for him to seek treatment before he can go out and commit crimes. However, when a crime is committed, you must pay for that crime. They believe that the criminal has no responsibility due to his mental illnesses, and thus should not be found guilty. Then put yourself in the shoes of the victim's family. Does it seem fair that the killer of your son, daughter, wife, or husband be absolved of all responsibility? Of course not. In our judicial system, a punishment must be given for a crime. A debt to society must be paid. In our proposed system, if a criminal does not understand the implications of his crime, he will receive treatment, which and after that point, he will pay his debt to society. No matter which way you twist it around, the insanity plea is a portion of our criminal system that must be abolished. There is no justification for relieving a criminal of all wrongdoing when he commits a crime. Justice may be blind, but she is not stupid. Thank you.
Judges, fellow debaters, and students of Easton High School. Can't you feel any kind of diseases such as schizophrenia or born with some kind of brain defect who do such? They can't control themselves. The insanity plea is here to help them. They could have done something that they didn't even realize that it was either right or wrong. How are they supposed to know? Control themselves. How can you blame someone for something they didn't even know they did? How can they be responsible? There is no fair way to say that they are or aren't responsible. That is why the insanity plea should remain in effect, because there are people in this world with mental disorders who commit crimes and don't even know it. How can they possibly be responsible? Why should it be abolished if these people desperately need help? Insanity, if put in a legal context, is a term designating a mental incapacity that fundamentally modifies a person's status under criminal or civil law. The entire issue of competence and/or fitness to stand trial is concerned with a person's mental condition at the time of the trial. The United States Supreme Court ruled that a defendant must have, quote, sufficient present ability, unquote, to be able to consult with and to be able to work with a lawyer. An American Law Institute's 1962 Model Penal Code replaced the McNaughton Law test by which it says, quote, a person is not responsible for criminal conduct if at the time of such conduct as a result of mental disease or defect he lacks substantial capacity either to appreciate the criminality or wrongfulness of his conduct or to conform his conduct to the requirements of law, unquote. Defendants who are acquitted on the basis of insanity are sometimes committed to mental institutions for long periods of time. The American Medical Association is only one of the many groups who support the concept of the insanity defense in criminal trials should be replaced by statutes that provide for acquittal and appropriate commitment under the, quote, mens rea, unquote, rule, which hold that a defendant, through mental disease or defect, lacks the state of mind required as an element for the offense charged. A person suffering from severe mental illness may be committed to a mental hospital for treatment against his or her will. In cases of severe mental illness, a person may be declared, quote, incompetent, unquote, to manage his or her own affairs, and care of all property may be transferred to some form of guardianship. By reason of insanity, a person may be prevented from exercising a variety of rights or privileges. Once it has been established that a person has committed a criminal act, the law then questions the intent of the actor, in effect inquiring whether the offender intended to cause harm by committing the act. The answer to the question helps to determine the question of guilt or innocence, and also the severity of the punishment. A commitment to a mental institution is the most common result of not guilty by reason of insanity verdict, and persons so committed under severe serve longer sentences than their counterparts in penal institutions. Michigan has abolished the insanity defense in favor of a plea of, quote, guilty but insane, unquote. However, the numbers of insanity pleas did not decrease, even with the, quote, guilty but insane, unquote, plea. Do we not want to be a compassionate nation instead of one who punishes people for things they didn't realize that they did? We should not abolish the insanity plea. It is needed for my reasons that I just stated. Thank you.
This concludes our debate. I'd like to thank the participants. Results will be in shortly.
We're all pretty
Thank them.
Sure.